it's effectively a contract's only as good as it's relevant to the circumstances. If people's circumstances change with time, they have children, they buy different assets, the positions change. Sometimes that contract becomes unenforceable, or potentially it's just not as binding. And I think that's, like you said, it's important to review those, because a contract is a living document. And the same thing applies to any, whether it's a business terms and conditions, whether it's a binding financial agreement between a relationship. A contract is a living document, and it's not set in stone. It must be constantly reviewed and revised and improved. Isn't that right?
Yeah, you're spot on. And bringing it back to probably an area you're more familiar with, Michael, is the lease agreements between landlords and tenants. And I had a client the other day actually that called me up and needed some legal advice. And he was a tenant. He'd been a tenant for about 10 years. He entered into two 5-year commercial lease contracts. Um, and what had happened was at the end of his 10 years, he realised that his bond, which he'd given the landlord to deposit into an interest bearing account 10 years ago, hadn't actually been in an interest bearing account, and he wanted to recoup the interest on that deposit. And the first question I obviously asked him was, why did it wait until 10 years later? Didn't you constantly review the contract to make sure that both of you knew your rights and responsibilities and obligations? And his answer was no. But then when he first came up with, well, there's no issue because I can recoup that interest from 10 years ago. Obviously, you know about statute barred claims. We can't go back more than 6 years, and that started making it a bit difficult.
Yeah. Yeah, that's the Limitations of Actions Act
Yeah.
in Victoria, but and it varies state to state and territory. But 6 years of contract generally in Victoria, and those sorts of things is a great example of being on top of your contracts, revising them, but understanding them. And if you don't understand them, ask your lawyer to explain them to you, because that's what we're here for. Quite often you'll get clients that will just say, "Oh, whatever, the lawyer handled that. I don't understand that." No, well, you need to understand it, because you can't. You don't want to pay your lawyer every single time you need a clause explained to you. It's going to get very expensive. So make the effort to understand it yourself. It's the same thing when I engage, for example, my IT people. Now they're speaking a different language. I don't understand all of it, but I take the time to understand it, because I need to know what is happening with my systems, because it's my business. And this is the exact same approach clients need to take when they engage us, right? Is take that practical approach of, well, this will save me costs down the line, and it'll also help me avoid disputes, because I'll understand the terms better, I'll apply them better, and in the context of the business, and then the risk is reduced, and the risk of disputes is reduced significantly.
Yeah. Well, what do you tell clients, Michael, or potential clients that ring up Scherini lawyers and you're giving them advice with respect to a contract? Like, do you inform them about the elements of a breach of contract and what those five elements are?
I think the first point we need to always go through is assessing whether there's a valid contract. A starting point is to look at the contract, and it's very easy to assume that a contract has come to you is valid, but it's quite important as a lawyer to go through those basic steps of assessing whether or not you've got a legally valid binding contract. And generally the most key elements are: there's an offer, a clear promise to do something; acceptance, so that's got to be unequivocal agreement to the offer; consideration, something of value exchange, money, service, etc. Number 4, intention to create legal relations. The parties must intend for the agreement to be legally binding. And number 5, certainty. The terms must be clear enough to be enforced. Now, you work your way through those elements to make sure first that you've got a binding agreement. And it's not until you assess that you should turn your mind to whether or not there's been a breach. And the client will obviously be upset, distressed, and believe so that they've got a case, but it's important to break down a problem in a methodical way and go back to basics.
Correct. And I think amongst those five elements as well, which a lot of people sort of miss, but it does come up I'm finding it's coming up more often than not in this day and age, but capacity, whether they had the capacity to enter into the contract, and that can be a lot of things, but sometimes it can be age, the age that they entered into a contract, and then also, their mental capacity as well. You get a few. I've had a few clients who it's not until you put them in front of a psychologist or psychiatrist who does some tests and they have an IQ level of around 70, but nobody seemed to investigate this before the person entered into a contract. And what that essentially means is sometimes they can have a reading level of about a 5-year-old, but they're entering into a pretty complex contract. So things like that, or whether they even had permission to have authority to sign on behalf of a company. That's another thing to look at.
Yeah, you're right. And look, that can have a big impact on whether there's a legally binding, enforceable agreement, and
Mm.
it can give rise to defences to the other side, and it can also give rise to a whole string of different causes of action, which are beyond today's discussion. But for example, it could give rise to a cause of action for unconscionable conduct. There's a special relationship, the disadvantage there. It can lead to all sorts of complications, and there's different levels of incapacity. There's incapacity from psychiatric conditions. There's, you could have, for example, someone with dementia, which is completely unable to understand what they're doing. As you said, there could be someone so elderly that their ability to understand is gone. And that's why it's important, as you say. I think that's a great thing that you've raised, that where there's doubt, capacity, including when lawyers dealing with your clients, you may as well just ask them to get assessed. And as part of that, there's ways to canvass that carefully with clients. And the number one thing you need to tell clients is that you don't want whatever occurs to be undermined as legally binding, because of the fact that the capacity has come out later, and subsequently been challenged. That could affect all sorts of things. So, whether you're dealing with clients or you're dealing with a client, in whatever industry, not even just legal, you really need to turn your mind to those things.